The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for oral arguments. We will have 3 oral arguments this morning with a quick recess between 2 and 3. And the 4th case is going to be submitted at this time without oral argument, and that is State versus Sam Daniel Abu Yum. That is hereby submitted without oral argument. Our first case today is Kluender versus Plum Grove, and it looks to me like the parties are ready. Mr. Prichard, you may begin.
Thank you. May it please the court and counsel, my name is Todd Prichard. I'm an attorney in Charles City, Iowa. My client is Mr. Kluender. Gary Kluender Jr. is a farmer in Chickasaw in Floyd County, Iowa. And a few years ago, he neglected to pay his property tax. It was carelessness on his part. It was an oversight. But the penalty for him not paying his property tax was the loss of his farm. A few $1,000s in an unpaid property tax bill means that he lost his farm worth conservatively hundreds of thousands of dollars with no actual documented notice. My contention is that the statute that allows this process to happen is unconstitutional in that it violates the Due Process Clause of the Iowa Constitution and the United States Constitution. Specifically,
Since you said oversight, aren't we talking several years here? I mean, I think oversight's when you forget to pay in November, but then 6 months later you remember. But weren't there several different cycles that would have been owing, and then several different documents and pleadings that would have been sent to him? So it's not just one oversight. Would that be correct?
the
You made any attempt to pay anything during that period of time?
Your Honor, it's simply, and as you are likely aware, when you forget to pay your property tax, you don't pay your property tax for whatever reason, then the certificate is sold and it's paid for by an investor. And so then essentially after 2 years, what the code system allows is that your farm can be, or your land in any case, can be seized or taken away.
All that. I'm trying to figure out whether there was any attempt on your client's part to do anything during that several year period.
And I think, you look at the unclean hands, if you will, that argument of, well, this taxpayer didn't pay his tax. It's true, he didn't. But then you look at what's the penalty in this case. He's not the only person that has failed to pay a tax. But then you look at, okay, you failed to pay your tax for negligence or for whatever reason, if it's carelessness or just an inability to pay. But then the punishment becomes, in this case, a huge fine. That's, in my mind, in my argument, is way disproportionate to what should happen, what's fair, what's just, what's equitable. And I think the other issue then is just...
Disproportionality, sort of, isn't that one for the legislature, an organization you're familiar with, Mr. Prichard, based on your background, right? Isn't that a legislative issue?
I think it is in terms of, my argument isn't an attack on this system of the tax sales system. My argument is that if we're going to go through this process, there need to be certain safeguards and procedures that are crafted and calculated to give the taxpayer notice that, hey, this is what's going to happen. This is going to be the consequence. And so when you get into the due process claim here, what our constitutional attack on 447.9 is that it's not reasonably calculated. So if you look at the case law, for instance, War Eagle is kind of probably the foremost Iowa case law. Then you look at the federal cases which apply, because constitutional analysis for due process under state laws is synonymous with and the same as federal law. The standard is what is reasonably calculated to give notice. Now,
Wish the Jones versus Flowers case, where the court said that regular mail notice would be sufficient to satisfy due process for tax sale purposes.
when Jones v. Flowers, the issue and what the court said was that there was an irregularity and that the state of Arkansas should have known, given the problems of notice, that actual notice did not happen. And so then there's a responsibility, and due process requirements is that something more is required. And so if you look at Iowa Code 447,
More, the court said, could be regular mail. If there's actual notice that certified mail wasn't delivered, then regular mail to the address would satisfy due process. So why isn't that sufficient here?
I don't think it's sufficient because, one, you've got an inalienable right of property interest, right? So under the Iowa Constitution, the second liberty interest identified, first paragraph,
Due process claim, why isn't Jones versus Flowers dispositive?
Jones versus Flowers is not dispositive because it doesn't provide the protection when you know that there's an irregularity. Here in this instant case, there's an irregularity. You had a fire. My client's house burned down. That's in the record. Two, you had an an unreceived certified letter receipt that didn't make it. And so here, the private actor, the Plum Creek Investments, should have known, hey, there's something irregular here. We don't know whether this person was notified, had any actual notice that their farm may be taken away.
That the regular mail was not returned and deliverable, so does that kind of counterbalance the irregularity? It's not totally uncommon for a certified letter to not be picked up, but when the regular mail was not returned as undeliverable, doesn't that cure any irregularity?
There's an argument that the regular mail made it. But then there's an argument that the regular mail didn't make it. And I think, what the statute says is that service is deemed complete upon mailing. One thing I always tell my clients is that, when you get your renewal for the Secretary of State's annual report or biennial report, don't throw it away because it looks like junk mail. It comes as a postcard. There's nothing in this statute that prescribes what form that notice should be in. Can it be dressed up? Can it be, in a way that's kind of fraudulent or bad faith in that it looks like junk mail?
I mean, isn't that for the legislature to make that call? I mean, is it for us to say what the mailing ought to look like?
This court to say that there's a violation of a constitutionally protected interest under due process. I think if the legislature was going to do this right, there would be some sort of prescription as to how this system's going to work, okay? And you see that like in the foreclosure statute, where there's, a color copy of the notice to the debtor.
Process claim, are you making a facial challenge only or an as-applied?
Facial challenge. That's invalid on its face. And I think,
assume then that this statute operates unconstitutionally and doesn't provide due process in any circumstance. Is that correct?
that this statute does not provide due process in that it's constitutionally defective.
And had signed for the certified mail.
Wouldn't have an argument that he,
Application of this statute.
it would take away his argument that he didn't have notice. But I think what's missing in this statute is the constitutional protection that due process requires. And so if you look at the Matthews case and the three-pronged balancing test, you take the right of the individual, the private interest, you take the government's interest, and you weigh and you say, what is due here under this, under the constitutional right that we're protecting? What's due under the interest of my client? And there is the argument, and my argument is that you have to have a system that protects their due process rights, and that's absent here.
View that once certified mail is not picked up, even though regular mail was not returned, that due process requires sending the sheriff's deputy or process server out to serve the client personally?
What my argument is I said, one, I think that would be the most protective. So if we had a personal service And that's certainly, excuse me, what other states have done. And where they've gone is because they see that there's this property right that's a strong right, and we're going to protect it. But I think what this statute lacks is similar to Flower v. Jones in that, hey, when there's something wrong, when we don't think that the person, we don't have proof or any documentation that this person was notified that we're going to take their land, the statute ought to require something more protective.
The personal service, I mean, this case is kind of unusual in that it's 45 acres, isn't that right? Something like that, of valuable farmland. Usually, a lot of times with these property tax sales, you know, you're talking about trying to effectuate personal service on an owner who may not care anymore, may have abandoned the property, and that's just another burden, isn't it? I mean, if you're talking about a facial challenge.
One, this statute applies to both private and state actors. Because if you read further in the first paragraph, I think, of 447.9, it gets down to service is deemed complete when it comes from either a private actor or from a state or a county or city entity that's giving this notice. Because cities can take over on a tax sale, okay? But again, if you look at this statute and you say, all right, say this isn't a private actor like Plum Creek, but it's Floyd County or it's whatever township. Again, there's nothing in this statute that protects due process when they know that there's an irregularity, such as there is here, where they didn't receive the certified notice. We don't know about what happened with a regular mail. And so again, you know, what I'm saying is, you look on one hand is, what is the constitutional interest here? It's property rights. It's inalienable under our Constitution. It's for my client, it's his way of life. I mean, his significant amounts of his income come from his ability to make money from these 45 acres. So now he doesn't receive a letter, even though he should have paid his property tax, and he maybe make the argument he's irresponsible, careless, negligent, or whatever it is. He doesn't get a letter, he loses his farm. How is that protecting his rights?
Ignoring what Justice Oxley was talking about, though, if the letter was not returned, don't we have some assumptions that we can make that it was received?
An assumption, I think, but my response is that you can make an assumption, but we don't have any proof. We don't really have any knowledge that this is what actually happened, that they received that notice.
Is that actually, that there needs to be evidence of actual notice for due process to be satisfied?
I think when you have this inalienable right, what's on the line here, there needs to be something that we can point to and say, this person knew what was the consequences of not paying their property tax.
What's your best case for actual notice? What case do you point us to that would require that here?
I think if you look to other terms, other practice within the statute, you know, other places where we do require notice, you know, such as civil process for district court action or things like that. I think if you also look at the
I mean an actual legal case. What case would you cite us to?
I think the Matthews test and applying the three-pronged balancing test of due process, and I think the Flowers case shows that, you know, when you know that there is an irregularity, you've got to take reasonable steps to make sure that that person had notice. When there's a failure of notice, then I think it becomes incumbent upon the person or entity giving notice that they've got to do something.
Actual question here about knowledge on the part of Plum Grove as to whether they actually knew that your client didn't receive notice. I thought, and correct me if I'm wrong, that your client admits here that despite the house burning down, he did receive his mail, or he was receiving mail.
Did not receive his mail?
Was receiving mail still that was sent to that address.
Factual basis here from my client is that he does not recall, never has any recollection of seeing anything from Plum Creek about this.
Terminating his tenancy, right? And so is it in the record where that piece of mail was received?
Later, yes.
Which address did he receive it at?
You know, I think I'm not for certain. I think it was the same address. There's some confusion here because my client's name is Gary Kluender Jr. His father's name is Gary Kluender Sr. They live out in the country. They live a few miles apart. So there's confusion in my mind. We've never made an argument because we didn't know if Plum Creek knew the difference between junior and senior.
In case there is evidence that he did receive some mail from Plum Grove.
He was given the notice of terminacy after the deed. That's correct, Your Honor.
Accept your view. What's the limiting principle? Or would this case then call into question a variety of other statutes that allow actual or certified mail for notice?
More in line with what other statutes do require, particularly like if you look at the foreclosure statute, if you look at the rules under initiating a civil case. Thank you, Your Honor.
232, termination of parental rights. You have to get personal service or restricted, whichever the court deems to be most likely to be successful. So, I mean, that's terminating parental rights. Certainly, that's right up there, if that not even higher than a case like this.
Expected a 232 question from Your Honor. I think, you know, just as what you said, Your Honor, with the court having to give notice that it most likely knows, will get and give actual notice to that person. You know, we, under 447.9, are only required to put an envelope in the mail. Doesn't say what it has to look like, doesn't say anything else. Certified and first class letter in the mailbox. No matter what happens after that, notice is good, you lose valuable farmland. Thank you.
Thank you. We now have Mr. Nervig.
May it please the court and Mr. Prichard. I think I want to first emphasize something the courts recognize, but it really needs to be emphasized, that I really think the Jones v. Flowers standard has been amply satisfied in this case. And I think the thing that needs to be emphasized from the beginning is that under Jones v. Flowers, the court in their dicta indicated that the statute would have probably complied with constitutional due process if a system had developed that would have provided for regular mail and certified mail. And so then the issue, after you have a statute in place like that, the constitutional issue becomes, well, was the mail by both methods properly addressed? And as the court has recognized this morning, the record shows that a later mailing of an eviction notice to the same address that the tax sale notice was mailed was actually received and admitted received by Mr. Kluender. I think it's important to really recognize the Jones v. Flowers decision was based on, obviously, analysis. And for the court to raise the question of what other method would have been acceptable and to come up with a potential acceptable alternative to include regular mail coupled with certified mail, they had a record of other statutes in other states. They didn't just invent that of their own accord. And I've been working personally on assisting the legislature with amendments to real estate laws for about 22 years. And this was one that I personally had involvement with. I think it's important that you recognize that there was a reason why the legislature amended the code sections to require mailed notice as opposed to the earlier personal service method. And I think Mr. Prichard is painting a picture that by doing so, the legislature was disregarding the rights of the taxpayer. And my involvement makes it really clear to me that it was just the opposite. And I'll just tell you what happened. Why would our legislature back in 1999 change a statute that required personal service of notices? And I can tell you exactly why, because I was responsible. I had served a tax sale notice on a mobile home park. And you know, mobile home parks have parties in possession in each of the mobile homes. So I was required to serve the notice on the park owner as well as each of the residents of the mobile homes that were in possession at the time. Well, the mobile home park had over 100 mobile homes, and the residents did not speak English. So not only did I need to find a process server, but I needed to find a specialized process server who could speak Spanish. And so by doing that, we got the notices served, but the expense of that service on those 100 mobile homes was extreme. It was over $1,000. And as you know, with respect to forfeiture statutes, foreclosure statutes like mortgage foreclosure and tax sale, when the plaintiff incurs costs, those costs become certified against the defendant. And in tax sale law, that means that when the property is redeemed after my costs of service of $1,000 were certified over by the filing of the affidavit of service with the treasurer, that meant that the mobile home owner, park owner, had to pay that $1,000 in addition to everything else he had to pay to redeem.
I want to talk a little bit about the War Eagle case and the Smith case. Why isn't this case in alignment with those two cases where we did find the notices to be bad? I think one was an FED action, one was an unemployment appeal. Why is this case different?
Well, with War Eagle, and that's a great focal point, because War Eagle was not about unconstitutionality of mailing of notice. It was very narrowly limited to the unconstitutionality of mailing an untimely notice. What it was focused on was there was a short 7-day period for notice to a tenant of an upcoming eviction hearing. And this court, and I think very properly, ruled that that just isn't enough time to accord due process. And it's not about, again, it's not about what the plaintiffs in this case are arguing for. It's something entirely different. And back in the Nicholson case back in 2009, the court specifically held that the procedures here, they weren't time-sensitive notices. These were notices that were given under a statute that required 90 days notice. And a notice mailed today under a statute that requires some action to be taken within 90 days after the mailing of that notice is totally different from a situation where the hearing is going to be held in the very next week. And what I want to say too is the record here doesn't reflect what happened after the court in War Eagle entered its decision. Well, I was on the legislative committee with the bar that was dealing with the aftermath of that, because Iowa real estate attorneys were taken aback. They were wondering what to do. There was some feeling that, wow, that means mailed notices out. And I called a meeting with legal aid for the tenants and representatives of the landlord interest to try to reconcile everything that was going on. And I also talked to
I got a different question for you. The plaintiff here is making an argument, I think, that the notice should, the type of notice or the means of notice should depend somewhat on the interest that's at stake. So if the interest at stake is a notice from the city, say that you have to pay for a new sidewalk, which might be a couple $100, maybe notice is one thing, but when you're literally losing your farm or your home, the interest is much higher, and therefore we need to have a kind of a more robust means of making sure that the person knows that that right is at stake. How do you respond to that argument?
just say that in War Eagle, the issue was exactly that it is a taking, it was an eviction case, so the person was losing their interest in the property, and the court held you that just wasn't enough time. What I did with my committee after we analyzed it, I said, I went to the U.S. Postal Service and said, well, how much time does it really take to deliver a notice by mail? And the Postal Service said, well, 3 days is pretty reasonable, 4 is more than reasonable.
Stuff's in the record, but I want to ask you, I want to divert your attention a little bit. Well, let me redirect you a little bit. Am I correct that your client sent notice to a home that had burned, but the guy admitted, I'm getting my mail there? That's correct? And also, am I correct that your client sent notice to the property at issue?
Yes.
So to me, doesn't that kind of indicate house burning, blah, blah, and he says he didn't get notice? That's really not probably a hard stretch to imagine, is it, with a burned house? And you even took the step of also sending it to another piece of property. Doesn't personal service, I understand your trailer park situation where there's hundreds of people. This is one guy. So is it really hard to believe that perhaps maybe he didn't get notice?
Well, Your Honor, in most cases, when a house burns, the property owner is still going to want to receive mail. So he's going to go to the Postal Service and he's going to change his address. And I don't know if that's how my client got notice of his true mailing address, but my client did, in fact, identify his true mailing address as shown by the fact that mail was received later on an action for mailing later. I think that's the critical point. And when we as attorneys do these notices by mail, we have to be very careful to serve persons in possession. You know, most of your Supreme Court decisions in this area for defective service have been failure to serve persons in possession because their interests aren't often evidenced in the record, like the owner's interest or a mortgage lender or a judgment holder. So we engage, and my client engaged in a significant amount of due diligence to determine potential addresses. Just in my follow-up on what happened after War Eagle, you'll see that I proposed in our committee, and the committee recommended, and the legislature approved overwhelmingly, an amendment after that. And the amendment now says that notice to mail under this section is deemed completed 4 days after the notice is deposited in the mail, to address the issue of you just can't mail a notice a week before a hearing. So now we have that section amended to 562A.29A and 648.5. That's what cured the constitutional deficiency identified by War Eagle. That's not an issue, and that's no longer an issue. The legislature's fixed it, but most importantly to this case, the legislature has fixed it by still allowing the mailed alternative for mailing notices in that particular fact situation. As far as the thing that was interesting to me, War Eagle, or Jones v. Flowers, My Iowa State Bar Legislative Committee had a contact from the Supreme Court clerks in that case because, yes.
Can I ask you another question? There's a lot of emphasis in the appellant's brief about how easy personal service is, and it's available and it's required in a lot of cases. Is personal service always easy or practicable in situations like foreclosures or other situations? Or should we accept the appellant's view on that?
My practice indicates that it's often very difficult when you're serving somebody who's in default and whose default may lead to his loss of rights in real estate. He's going to make himself hard to find. And that's just a common sense fact.
Foreclosures under 654.1, doesn't the legislature require personal service? Why the difference between foreclosures and the tax notices?
Your Honor, I think that's for the legislature to decide. In a number of statutes, the legislature provides for alternative means of serving notice. And when the yes.
Due process, and if we're looking at the Matthews balancing, the interest in the tax sale would be pretty comparable to the interest in a foreclosure, wouldn't it, from the property owner's perspective? So is that
different situations? And again, I think the legislature considered that when they had a statute in place in 1999, and they determined that they wanted to change that.
Understand that, and I think that it's the plaintiff's contention that when they did that they then violated his rights to due process. So that's what I'm trying to see. Is the personal service for foreclosure, is that evidence that maybe the legislature believes that personal service is important when it comes to those significant property rights, and the idea that personal service is not that difficult even when you've got someone in a similar situation between foreclosure and tax sales?
I think if the legislature believed that, Your Honor, then when they amended the sections of the code requiring service to be switched from personal service to mail notice, they could have very easily put in service shall be made by personal service, regular mail, and certified mail. They could have added all three, but they chose specifically to remove the requirement for personal service. I think that's a strong indication, in fact, a conclusive indication of legislative intent at the time.
Own and allowing mailed service for tax sales? Or are there...
You know, I haven't really studied other states, Your Honor.
Anyone else? Questions? You may briefly wrap up. You have.
Okay, well, I just think, members of the court, that the issues in this case have already been resolved. I think the judge's ruling on summary judgment is beautifully well written. I don't even think I needed to brief the case after his ruling. It stands for itself. I think the Nicholson case is beautifully well written, and I think it resolves the issues with respect to War Eagle. I think the idea that the
Like a real quick summary.
okay, well,
It's like what you want us to do. Reverse, sustain.
I think what we want is for the court to sustain the statute. We think the statute is constitutional on its face, and we think, not that it matters to you, it's also constitutional as applied in the facts of these cases, because the record clearly shows that the notice was delivered to the address at which the addressee was receiving mail at the time of the notice. Thank you.
I'm going to say something I think might be shocking. As a member of the legislature got it wrong. And it's not the first time, not the last time. The legislature failed to balance the rights, the liberty interest of my client, people in the situation of my client. It took, as as Mr. Nervig explained, it took a system that did require, before 1999, personal service, in line with other statutes. You know, a system that said, you know, if you can't get a hold of this person, there are other ways to get a hold of this person, or to give notice, you know, through publication, you know, with leave of court and things like that. But, you know, when you hear the legislative history as explained by Mr. Nervig, it changed it for what? For the convenience of the certificate holder. Okay, that's the decision that the legislature may have made, and maybe that was its reasoning at the time. It's unconstitutional reasoning, because as was explained, if you balance the rights at interest here, you have to say, what is protective under the Constitution? What are the constitutional demands for protection for the liberty interest at stake? And they're high.
Earlier, you said that the Iowa claim is coextensive with the federal claim, right? That they're the same, it's the same law.
Analysis of due process under Iowa law tracks federal.
Court has said that we don't apply Matthews when we're dealing with issues of notice, and instead we apply the Mulaney test about sufficiency of notice. But I keep hearing you argue about Matthews, and you haven't mentioned Mulaney.
Mulaney too. I mean, because Mulaney, it gives a balancing test, and it's really, in my reading, it's the same framework, okay? And it says what is required. How do we safeguard these rights? And so I think, you know, it's still the balancing test, where you take liberty interest at stake, protective process to protect those rights.
Seeing irregularities here that weren't present in Jones, and I guess I don't understand exactly what it is you're referring to. So here's what the court said in Jones. There was certified letter marked unclaimed, so there was actual knowledge that the letter wasn't delivered. And then the court goes on to say one way to cure this, which they call a reasonable step, addressed to the possibility that the notice wasn't received, was to put it in regular mail. And from the Supreme Court's perspective, for federal due process purposes, regular mail is sufficient notice, and you're telling us that the Iowa claim is the same. So what fact here is different than in Jones?
What I read with Jones, and what I'm taking away and arguing with Jones, is that it says when there's an irregularity, where there's, in Jones it was the unclaimed certified letter.
Have here, okay.
Have a burned house, you also have other factors. And what I'm saying is that it's not protective enough. You know, and then you look at, okay, the first class mailing. Again, there's no assurance, there's nothing in this statute that says, you know, a first class letter to me is not reliable to give that person notice. It's just not reliable, it's not enough. You know, it doesn't provide the protection, the adequate notice.
The legislature, but the U.S. Supreme Court got it wrong. Is that what we have to believe to rule for you?
I don't think the U.S. Supreme Court got it wrong. If you look in what the holdings have been, starting with Hanover, and then Jones, and then Matthews too, is that when you have a due process right, you weigh the interests.
Regular mail is okay and under the facts of that case, and your additional fact is the burnt house, but we've got record evidence that your client was getting his mail anyway.
Where my argument is that is not protective. I mean, I just don't know how to say that. It's not adequate protection for the citizen.
In the case of foreclosures, you had mentioned publication, right? So in a foreclosure situation, if you can't achieve personal service on somebody, you can go ahead and just do service by publication, which just means putting it in the newspaper a few times, 3 times, I think, right?
Of court. I mean, they're, you know, through the normal rule of court process.
No, and we foreclose houses in Iowa all the time under those circumstances without any sense whatsoever that there's an actual, you know, reading of the newspaper by the homeowner or any kind of actual notice. Isn't that true? Okay. And so there's actually, I don't know how that's different from a fairness or procedure point of view in terms of your actual notice argument.
What it is it's the last step in attempts, right? We've attempted personal service. We've attempted to go through this route. Maybe the person's absconding, maybe their whereabouts are unknown, whatever the case may be. But then there's this process. Here we have no process. You put a first-class letter in the mailbox, and we're good. The last thing I'll say is War Eagle, and the case is sided with Nicholson. This isn't a time analysis.
Rice?
This isn't a time analysis. This is a rights analysis. What is appropriate given the liberty interest at stake? I ask you reverse the district court's decision with instruction for finding that the notice provisions of 479 are not adequate. Thank you.
Case of Kluender versus Plum Grove is hereby submitted, and we will allow the attorneys an opportunity to change, and we will hear the case of Euler versus Graham Group.